All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you to Dean McGasky for opening the court today, and thank you, Marshal Salou, for being here today. Good morning, or good afternoon. Welcome to your North Carolina Court of Appeals. My name is Chris Still, and I'll be presiding today. To my right is Judge Toby Hampson. To my left is Judge Fred Gore. We have one case on the calendar. It is Bryant versus Fields, and we'll hear from the appellant. And let us know if you want to reserve any time for rebuttal.
I do, Your Honor. Mr. Chief Judge, Judges Hampson, Judges Gore, my name is Mike Toddy. May it please the court. I'm here from Stevens, Martin, Vaughn, and Toddy here in Raleigh. With me is my colleague, Ashley Fox, who also signed on to the brief. We are humbled to represent Mr. Fields in this matter. He's the appellant, and thank you for your time this afternoon. It's a privilege to be here. I would like to reserve 8 minutes for rebuttal. I'm at that period in my life where I can see you with my contacts, but I can't see the pages in front of me, so if you'll bear with me.
That is fine.
Mr. Fields appeals the denial of his motion to dismiss plaintiff's...
Let me ask you a question about that.
Sure.
This is an interlocutory appeal,
It
right?
is.
So you're required, I think based on our case law, to say in your statement for grounds for appellate review why we have jurisdiction. And all you say is this is an appeal from the appellant judgment of the Superior Court. So why do we have, I don't see, I mean, I know that there's a lot of case law saying that when you're arguing denial based on personal jurisdiction, that's a substantial right. But you don't argue it, and we have case law. Or do you? Do you argue it somewhere else? Because I'm just reading on page 6 of your brief, this is an appeal for interlocutory order pursuant to blah, blah, blah.
Right, and 277B is the statute.
But I'm just with that. Typically, I think you're required to tell us why you think there's if it's interlocutory, we have I'm just looking at a case from 2015 where our court says that Rule 28B is not jurisdictional normally, but if it's an interlocutory appeal, you got to tell us. We don't make arguments for you. You have to tell us why.
Judge Dillon, I've never been presented with that question before, and I thought invoking 1-277B, which says any interested party has the right of immediate appeal from an adverse ruling as to the jurisdiction of the court over the person or property of the defendant.
So that's what it says. So okay.
I believe so.
Okay.
I did not mean to offend the court in any way. I thought that was sufficient. But Mr. Fields is appealing the denial of his motion to dismiss the plaintiff's twice amended complaint. There's a third request to amend pending for lack of personal jurisdiction regarding internet postings allegedly made by Mr. Fields regarding Mr. Bryant and Bryant Enterprises, which ironically enough does business as North Georgia Communications. In my view, the order that Judge Rozier entered in this case is not abundantly clear as to whether the trial court found general or specific jurisdiction. However, we believe that the record is clear that neither exists and that North Carolina's courts do not have personal jurisdiction over Mr. Fields. At the outset, I respectfully ask that you focus on the fact that the plaintiffs had the burden of proof to establish facts demonstrating personal jurisdiction over Mr. Fields. The applicable standard of review is whether the findings of fact are supported by competent evidence, and the record is clear at pages 232 to 239 that Judge Rozier made extensive findings of fact. Competent evidence is evidence that a reasonable mind might accept as adequate.
This was done on affidavits. Is that correct?
Yes and no.
Okay.
The pleadings that the plaintiffs have filed have been verified, and as I remarked and plan to remark here, they're just rote statements of hearsay without, Mr. Fields created this website without any other evidence, not on information and belief. We filed affidavits in response to the jurisdictional allegation made by the plaintiffs, which refutes it, and then Mr. Bryant added additional affidavits. I believe, if I remember correctly, Mr. Bryant filed 3 affidavits and we filed 2. There was no live testimony at the hearing.
Right. So functionally a battle of affidavits or verified pleadings.
Right. And in that regard, and what I argued to Judge Rozier, I would argue to you that just because you verified an allegation of fact without more doesn't make it competent evidence. It has to be, If Mr. Bryant filed an affidavit that said Mr. Fields hung the moon, that doesn't make it so. You would be able to show, well, here's the document. He makes allegations like Mr. Fields created this website without any evidence that supports that. It's just a rote allegation without any supporting documentation. We don't think that's competent evidence.
So one interesting thing I always think about these personal jurisdiction issues is they can kind of be decided at various sort of procedural points, right? They can be decided straight up on the pleadings, on affidavits, similar to summary judgment, or we could actually have a trial or even a mini trial on the facts of this case. Do you contend that then that there are issues of fact that would still need to be resolved by the trial court on this record?
I don't think so if the court does not accept what I consider to be rote hearsay and conjecture as competent evidence. If you believe that that needs to be challenged, perhaps so. In addition, at the hearing on this matter, right before we argued our motion to dismiss, Judge Rozier allowed the third amended complaint, which was, amended complaint, which itself was verified. We did not consider that to be a pleading in the matter because it had not been accepted, and we argued it anyway. So if you don't accept the evidence of what we have a problem with, which we've stated in our brief and I'll address here, then I don't think you need to go back. If you're saying this needs to be explored more, certainly that's possible. There are so many allegations without any supporting foundation that it's just hard if we're playing
So at the
whack-a-mole.
hearing, you weren't allowed, you didn't cross-examine, there was no live testimony. Did you ask for that?
We did not.
So then why wouldn't this just go to the weight? I mean, if I testified, blah, blah, but I mean, to anything, I said this is true, but I mean, I guess you would cross-examine me if you had an opportunity to, but I mean, why isn't it, I mean, because it ended up to the trial court to make the findings of fact here.
He made the findings of fact, in my belief, on the things that we complained to him weren't competent evidence. The order he entered does not cite to the specific parts of the record that he was relying on in making those findings of fact. Part of what we talked about in the argument itself is that Mr. Bryant, the Brian Fields and Mr. Bryant confuse me at times, and so if I misspeak, I'll try and correct myself. Mr. Bryant filed affidavits that would say things like the defendants did this, and Mr. Fields is in Florida and Mr. Galini is in Texas, and it was very hard to understand who was he attributing this conduct or speaking to, and we raised that with Judge Rozier. At the end of the day, Judge Rozier let Mr. Galini out, despite him having done business with Mr. Bryant, and kept Mr. Fields in, despite Mr. Fields never having done business with Mr. Bryant. I couldn't reconcile those two, and that's why we brought this appeal. Mr. Fields lives in Pinellas County, Florida. He's never lived in North Carolina. He does not have family or friends here. He does not vacation here. He doesn't have a business interest here. He came to North Carolina 18 years ago for professional training. He came 17 years ago. He visited for one meeting for which he didn't get paid. When he posts on the internet, his postings are intended for a worldwide audience, general audience, and not directed at anyone in particular. He does not target North Carolina in his postings or anyone in particular. And the only things Mr. Fields has ever published or disseminated about the plaintiffs were posted online via Facebook or on a publicly editable wiki website posted on servers located in Tampa, Florida. We believe that this court's opinion in Daly v. Popma, which is my pronunciation for that case, at 191 NC App 64, its analyses and the references it makes to the Fourth Circuit authority adopted by this court resolved this matter in Mr. Fields' favor. In Daly, a man from Georgia who only less than a year, I guess it was just over a year ago, moved from Cary, North Carolina to Georgia, posted about Mr. Daly on the internet. And he said some unkind things. Those are recited in our brief, and I won't do that here given the fact that this is being live streamed. But they were unkind things. And Mr. Daly argued that because of the effects of the posting occurred in North Carolina, there were sufficient minimum contacts. The plaintiffs make the exact same argument here. In referencing the Fourth Circuit's analysis in the ALS scan case as refined by the Young v. New Haven advocate opinion, this court said in Daly that minimum contacts depends on the quality and nature of defendant's contacts with the state. It's a case-by-case analysis. Must demonstrate that the defendant purposefully availed themselves of the privileges of conducting activities in the state, within the state, and then delves into the ALS scan case, or test, which is that the defendant directed activity into the state with a manifested intent of engaging in business or other interactions with the state, creating a potential cause of action for the plaintiff in the state. The court in Daly said that access to the postings in the state is not enough, and that knowing the person is in the state is not enough.
So Daly, as I read it, and always open to correction, was focused on the internet postings or whatever. Here, aren't there findings of fact that there suggest there was more to this overall transaction than just the internet postings? For example, your client specifically reaching out to the plaintiffs, asking about the radio product and the process, direct messages separate from social media posts, but direct messages and contacts directed into North Carolina, directed.
Right. There were two. One in, I believe, January of 2021, responding to Mr. Bryant's ad. Mr. Fields contacted him and said, "Can I get some information on this?" At Mr. Bryant's invitation, he said, "Call me." And he called him, got the information, did not make a transaction. About a year later, almost the exact same thing happened. Mr. Bryant went and shared the information via the internet, via the chat, invited him to call him, and based on his pricing, he did not have no transaction. Conversely, Mr. Galini did the exact same things and bought from Mr. Bryant. Mr. Galini was dismissed for lack of personal jurisdiction, having made a transaction, but Mr. Fields, having not made any transactions, was kept in the case. I cannot reconcile that set of facts based on, it was the same hearing, same information.
I guess that sort of begs the question that where, what do we look at as far as the transaction? Or is our focus sort of squarely on these, allegedly defamatory postings to the public? Is that where we limit our personal jurisdiction analysis, or do we look to these other contacts?
I believe that whether the Daly case held that whether the internet postings confer jurisdiction in a particular forum hinges on the manifested intent and focus of the defendant. Understandably, Mr. Kirby and his client want to talk about the unsavory things that they attribute to Mr. Fields, and that the effects of those things were felt here in North Carolina by North Georgia Communications. But the Daly case stands for the proposition is you look at what the defendant did. There are cases that are analyzed in the Daly case which talk about, well, in addition to posting stuff on the internet, they sent 200, 500, 1,500 mailings into North Carolina. There's no evidence of that. In addition to internet postings, they did $150,000 worth of business with people in North Carolina. There's no evidence of that.
The mere fact that he was attempting to enter he was trying to enter a contract or negotiating to enter into a contract with somebody in North Carolina, but just not do because of the pricing, you don't think is enough?
I don't think that's enough. Otherwise, I have a friend who's looking at a car in Florida, and he made an inquiry of the car dealership last week saying, "Can you tell me more about this car?" I don't think that subjects him to jurisdiction in Florida. Otherwise, then the whole second prong of the test of the long-arm statute and does it meet due process is just disintegrates.
Well, counsel, you say that's not enough, but then part of your example is 5,000 mailers along with. What is your argument that is minimal? What is your argument of what is minimum?
The case says you have to have a manifested intent that you were trying to transact business here. The only two instances it didn't happen, and they were in response to Mr. Bryant's invitation via an advertisement and an express request that you call. I'm not aware of a case where if somebody says, "I invite you to call me in Kansas," suddenly I'm now subject to personal jurisdiction in Kansas. If I'm upset with you and I post on a Yelp page that I did not like our conversation.
So is that only in the affirmative, or could that not be argued that or affecting business in a negative way? Because obviously calling and trying to get a business deal is in the affirmative. Could there not be an argument that trying to do something to affect business in a negative way could be minimum contact?
I think, and there's case law analyzed in both the Daly case and otherwise cited in our brief, where if somebody is doing that, they're sending information to people in North Carolina to say, don't do business with Ken Bryant, that's enough to confer jurisdiction. You've got the record, the voluminous attachments to all of these pleadings. You will not find anything that says, hey, good people of North Carolina, don't do business with Ken Bryant, or to the good people of North Carolina, you need to look at this. These are general statements about, general in a sense of a geographical standpoint, about his experience with Mr. Bryant and what he found out about him in looking into him. They're unsavory, I'll give you that. I don't know that most of them are defamatory, but I don't think by posting in Florida about the things he found out about Mr. Bryant or his speculations as to, what his past was like, warrant personal jurisdiction here. There is, to me, a qualitative difference in saying on the internet, I don't particularly care for Mike Toddy, I think he's a lousy attorney and all of that sort of thing, versus, hey, you in Raleigh, don't hire this lawyer, he's a bad guy, he steals from his client's trust accounts or whatever it might be. I think there's a fundamental difference between the two.
I may be going into unfair territory here, and you can tell me if I am, but I don't remember seeing discussion, and forgive me if I'm just overlooking it, about the sort of the most recent U.S. Supreme Court case in the Ford Motor Company case, which basically talking about, that's more of a stream of commerce type case, but within that context, sort of the takeaway, one of the takeaways from me from that case is that it wasn't really a defense to Ford for Ford to say, hey, we were disseminating or we were marketing and stream of commerce to all these states and worldwide, to avoid personal jurisdiction there, right? There was sort of a focus on, well, that's true, but there were specific things that you were pushing into the particular form in that case, and I forget what that form was.
I agree with you, and I don't think the record has any competent evidence of that. I will acknowledge that Mr. Bryant has alleged things without any foundation that are not true, but obviously at this point I can't prove that. To say that one of the allegations is that Mr. Fields and Mr. Galini registered a website. There's a way to find out who did that and provide that evidence. It just says it baldly without any supporting evidence. I don't think the record has anything that goes beyond, I'm talking about Ken Bryant here on the internet. I'm not targeting it to North Carolina. I'm targeting it to North Carolina. I'm targeting it to people in Western North Carolina where Mr. Bryant's enterprise is. It's just not here.
Is this, kind of going back to the original question here, just procedurally, where these facts have just been made on affidavits without live testimony at this sort of preliminary stage of the process, if this case were to go to trial, and for example, there was no evidence as to who created these websites. There was no evidence as to who created the meme, posted the meme, those kinds of things. Do you believe there's any preclusive effect from this preliminary order to you making a motion to dismiss at trial based on that lack of evidence, if in fact that's what it showed? Sort of similar to...
Or motion for summary judgment, I think.
Yeah, sort of like, is this akin to that, where what we're talking about here is more, there's been a forecast of evidence. I know you would disagree with that characterization, but there's been a forecast of evidence, but that's not preclusive at trial if in fact that evidence is not brought forward.
I agree, but I think the whole notion of the due process aspect of personal jurisdiction is, should we have to have that rodeo here versus in Florida? Mr. Bryant has sued Mr. Fields in Florida. Because of the hurricane, he's not at his house, so he hasn't gotten service. But there's a lawsuit pending in Florida. He can have that. I invited him to do that at the hearing when all of this was decided. He sued Mr. Galini in Texas. I believe he's gotten a default judgment against him. And so we can have those very issues, but I don't think under the fundamental notions of fairness and due process that there's a record that shows it should be done here in North Carolina. Mr. Bryant isn't even in Wake County. Mr. Bryant's in Haywood or Clay County. Only his lawyer is here in Wake County. So it would be highly inconvenient for both of them to have that discussion and the vetting of evidence and that sort of thing. I believe that we will ultimately find that Mr. Bryant had no basis to make the allegations that he did, and he's doing so solely to get personal jurisdiction because he's upset with Mr. Fields. He knows he can go to Florida and do it, and he's done it, but we're still pursuing this. And we think that the best course is to let Florida action run its course, and that can be decided then.
I guess, counsel, at the end of the day, couldn't the same argument of letting the process run its course be argued because there is potential issue of material facts without it being flushed out to say, well, let the process run its course, whether it is in Wake or whether it is in whatever other county he's here. But couldn't the same argument be said because there is a strong likelihood of what you're saying without any forecasting of evidence that there's no there with the evidence?
I completely agree with that, Judge Gore. I think the issue is, and I didn't mean to, I don't think I answered your question on point because I got distracted. The summary judgment is certainly, I think, something that is ripe ultimately in this case. The issue is, does that happen in North Carolina or Florida? We think it should happen in Florida. We don't think the minimum contacts, specific jurisdiction, and certainly not general jurisdiction based on what we've talked about, is here. I think the second prong of the jurisdictional consideration, without question, I can't imagine a situation where the first prong of the long-arm statute in North Carolina not reaching everybody in the United States makes it. The issue is it fair to bring it here? And so that's what we're focused on. I think whether it's here or in Florida, yes, absolutely, there are things to be resolved. To Judge Hampson's earlier point, if it needs to go back to the trial court to have an evidentiary hearing to say to Mr. Bryant, what's your basis for saying this? Maybe that's fine. But it was his burden at the time to bring competent evidence to establish personal jurisdiction. We don't think he did it. I'm not going to repeat myself. I can't reconcile what happened to Mr. Galini versus Mr. Fields.
Are there a lot of cases, would you say, around the country where the issue, that there's a personal jurisdiction issue and the case is about somebody defaming somebody on the internet?
There are bucket loads of them.
Now, is there a bright line where the line is, or do they seem to cross?
So
and we're sort of being asked to make a call here.
I pulled the Young v. New Haven case. In all candor, we did not know why we were being asked for oral argument here. It wasn't obvious to us. And that's fine. We're here. We want to answer your questions. I pulled the Young v. New Haven case, and I think there are 13 distinguishing cases in North Carolina from that opinion. And you're like, oh, maybe I've missed something. And I went through all of those, but it makes perfect sense. If it's on a case-by-case basis, you look at the facts that are asserted via competent evidence, and you say, this is enough, this isn't enough. I think there's a bright line in a standpoint of solely harm happening in North Carolina is not enough. You have to have that manifested intent of crossing the state lines to do something. And the case law in Daly and the ones that it cites says that just posting on the internet and knowing that the person is about whom you're talking is in North Carolina.
What if it was your client's intent? It was found that it was his intent to harm the defendant, the plaintiff. If he intended to harm his, I mean, even though he does it from Florida, my intent to do this, even though I'm putting it on Facebook, is I want him to lose all his business in North Carolina. Does his intent matter, or does his intent really doesn't matter?
I think it matters if he went into he manifests the intent to go into North Carolina and say, hey, people in North Carolina, don't do business with it. It's not in the record. There's speculation of it in the record, that X many people, because there are so many people in the state, they're probably North Carolinians, and so when he's talking to it, they're North Carolinians listening. The Daly case says that doesn't matter. It has to be that manifested intent to come across the state line. And so we think that's just not in the record. I'd said in our brief, we're in that untenable position of proving the negative.
I got you.
And so it's difficult to say, you know, here's the type of thing you could be looking for. It's not here. As I said, there's no competent evidence of mailings. There's no competent evidence of transactions. There's no competent evidence of targeted communications specifically at people in North Carolina. It's just
so we need to look at what he did. Okay, I don't want to eat into your rebuttal time if you want to say the rest of it.
The other thing I just want to mention, because it's in the plaintiff's brief, and then I'll sit down, is that there's a whole lot about Mr. Bryant's speculation that Mr. Fields created stickers and passed them out at a ham convention in Dayton, Ohio, and sent mailings to people around the country. A, That's not competent evidence. There's nothing in the record that shows, other than Mr. Bryant's allegation, that any of those, Mr. Fields did any of those things. But handing out stickers in Ohio does nothing to avail you of personal jurisdiction in North Carolina. Mailings to people throughout the country does nothing to establish personal jurisdiction in North Carolina.
What if you mail in what if some of the mail went to North Carolina?
If some of it went to North Carolina, perhaps. It's not in the record.
Okay, that's fair.
Unless there are further questions, I'll save my time for rebuttal. Thank you very much.
Hear from the appellee.
Chief Judge Dillon and Judges Gore, Hampson, if it please the court. I'm John Kirby, and I represent the plaintiffs in this appeal. The lower court heard extensive arguments on the issue of personal jurisdiction and then entered a decision and a judgment, an order with detailed findings of facts, finding that there was personal jurisdiction over defendant Fields, and we are simply asking this court to affirm that ruling. One of the issues that's been discussed here a good bit this afternoon already is the issue of in essence, the standard of review or how these are to be reviewed. And there actually are fairly clear parameters on how this is to be reviewed. We cite this in our brief, and the case I used just to set forth procedurally how we look at personal jurisdiction is actually the Daly versus Popham case, which we've been talking about. But I cite that case here primarily for the purpose of setting forth how the lower court is to look at the issue of personal jurisdiction. And the basic framework is that up front at the beginning of the case, you do have some type of a hearing at which this issue is vetted and personal jurisdiction is determined. And if it is determined at that proceeding, then there is going forward. If not, obviously there's not. But the basic parameters are that what the court is to look at are the allegations from the complaint, except to the extent that the defendant rebuts those through an affidavit. So we can look at affidavits. We can also look at allegations of the complaint, even if it's not verified, even if it is hypothetically hearsay. Those allegations are taken as true, except to the extent that they are specifically rebutted by the defendant. Just to quote briefly from the Daly versus Popham case, but again, they go into great detail. This area of law has been addressed in some detail. The court in that case wrote, usually personal jurisdiction issues are presented in one of three procedural postures. One, the defendant makes a motion to dismiss without submitting opposing evidence. Semicolon two, the defendant supports its motion with affidavits. I'm not going to read the rest, but basically they go through and talk about all the different scenarios in which this can occur. The posture this case is in, I would submit, is what the court is to look at, what Judge Rozier was to look at, and what you were to look at are the allegations of the complaint, and they were in fact verified in this case, and the affidavits. If the defendant specifically rebutted something that we alleged, then that rebuttal is to be taken. I would submit the only specific thing that Mr. Fields rebutted that we alleged is that he created this, what we call a meme, M-E-M-E, an image. That's the only thing he specifically disputed.
But what if your client had, in an affidavit, and it's the sworn complaint, said that Mr. Fields had done X, and Mr. Fields says in an affidavit, I didn't do X. Is it up to the trial court to resolve that? What do you do if there's a conflicting affidavits as to a material fact?
If Mr. Bryant had some basis for his assertion, and obviously Mr. Fields would know whether he did or did not do something, then yes, I submit that the lower court would have to make a finding of fact if you had competing factual assertions. I would submit, though, that on this case, there actually weren't that many conflicting points. Again, Mr. Fields did deny that he created this thing that we call a meme. We're taking that at face value. We're willing to assume he didn't create it. Of course, we say he posted it, he used it, he had some involvement with it. But in this case, I don't think there actually were any conflicts that I can recall that the judge had to resolve. If we look at all the affidavits and the complaints that were filed, the facts are fairly straightforward. And again, if Mr. Fields disagreed with some allegation, he could have submitted an affidavit and denied that particular point. But from a procedural posture, that is what we are to look at on this record. It's the same thing that Judge Rozier was to look at. So the issue becomes, what are the facts that are then relevant to the issue of personal jurisdiction? So if I can spend just a couple of minutes talking about the facts, because this becomes very important to the issue of whether there is, in fact, personal jurisdiction. I'm sure your honors have read the brief, so I don't want to go over every detail of this, but I think some of this is pretty important. This case did start off with what really kicked this off was Mr. Fields. He created, or at least he had a meme, which is like an image. It was an image of Mr. Bryant's face holding up a card that says Motorola, and under it, it's typed, "It's just been revoked." Mr. Bryant is a Motorola dealer. In the Motorola world, that's a big deal. There are only 4 Motorola dealers in the whole state of North Carolina, so that's a pretty important license or a dealership to have. This was posted on a Facebook group that was specifically dedicated to Motorola users. So this is targeting Mr. Bryant's audience. His customers, his peers are seeing this, and one looking at this on its face would say it appears that Mr. Bryant has lost his Motorola dealership. That's what kicked this off.
But it wasn't like a North Carolina Motorola group.
That is correct. This was nationwide. That is correct. That would be a nationwide group. It would, of course, include people in North Carolina, but right, it's not just a North Carolina group. That is what kicked this off. After that, Mr. Bryant tried to
So you're not relying at all on sort of the initial communication between the two parties regarding the radio and the product and the process and all that. You're not relying on that for personal jurisdiction.
I do think that's relevant. The fact, in other words, that Mr. Fields had reached out to Mr. Bryant, they had communications, they had phone calls, they had some messages back and forth. That is relevant. That's not all that we're basing it on, but I do think that's a part of the puzzle. And if you look at the cases talking about personal jurisdiction, those types of communications, whether it be by mail or phone call, text, email, the courts often do look at those things. But I certainly wouldn't rely on that alone to confer jurisdiction. But that's a part of the overall puzzle. There were communications. Mr. Fields was seeking information, proprietary information from Mr. Bryant on one of those occasions. So Mr. Fields posts this on the Facebook group. Mr. Bryant is alarmed to see this. His customers are calling him saying, "We've seen this thing. Has your dealership been revoked?" He tries to figure out what's going on, tries to get this resolved with Mr. Fields without going into all those details. The actual messages they sent back and forth are in this record. But basically, bottom line, Mr. Bryant couldn't get it resolved. What happened at that point, and this is where it becomes relevant for purposes of personal jurisdiction, is this case goes far beyond just a regular plain vanilla defamation case. If this were a plain vanilla defamation case, we would probably be in the world of the Daly versus Popma case we've talked about, the Young versus New Haven case. I'll talk about those in just a moment. What happened in this case is this case spiraled off in a very strange direction. Basically, Mr. Fields at this point embarks on a campaign to harass, and I'm not using hyperbole here, harass and torment Mr. Bryant and his business. And just to walk through some of these things that he did, he created what's called a wiki page. It's kind of like Wikipedia, but it's not Wikipedia, but it's the same concept. He created a page about Mr. Bryant that had his image on there, has information about Mr. Bryant. It's basically attacking Mr. Bryant. This particular page says that Mr. Bryant is a scummy realtor. It attacks his educational credentials. It attacks him as a radio dealer. It says several things along these lines about Mr. Bryant. There's then a second wiki page that Mr. Fields creates Mr. Fields basically dredged up a 40-year-old criminal matter that Mr. Bryant had been involved in. Happy to answer any questions about that. I don't want to spend too much time on it, but basically, Mr. Bryant, about 20 years old, was involved in a criminal matter. He basically did his time. He went through a federal program. He went through a program that expunged the record. The record was supposed to be completely expunged. The purpose of this program is basically to let people have a fresh start.
How does this go to the North Carolina's contacts? This seems like you're just arguing that you got a case. I mean, we don't, and that's not really what's before us. So he posted a lot of things on the internet. So
Right.
Where does North Carolina come into play with that?
So the point is the extent and the nature and the lengths to which Mr. Fields went to harm Mr. Bryant. But the main point I'm making is this is not just a defamation case. So he creates the second website. he obtains this information, which was illegally obtained. This is illegal information. The public is not supposed to have this information. It's only out there because someone stole it, basically, from the Pacer database. Mr. Fields got it and posted this information.
Where was he convicted in the 70s? Where was that at?
That was in Florida.
Because that was, it wasn't in North Carolina. Okay.
Yes, sir. Yes, sir. And so he creates a second Wikipedia page. He also posts this meme again on his own website. Mr. Fields has his own website. It's called www.fhams.com. I can't say the whole website, but he posts more information about Mr. Bryant on his own website. And then he brings in Mr. Galini, and this is where Galini comes into play. He then uses Mr. Galini to post these links to these harmful websites back at that Facebook Motorola page. So these links that now contain this harmful, damaging information about Mr. Bryant are now posted back at the Facebook page. But it doesn't stop there. This is the point. Mr. Fields continued this campaign. In the amateur radio world, people have what's called a call sign. It's like 5 or 6 letters and numbers that identify that person, kind of like a license plate or a bar number. Mr. Bryant's happens to be K1DMR. Mr. Fields took that call sign and basically went out and cyber squatted on those websites. He took websites k1dmr.com, .net, and .org. So there is actually a statute on cyber squatting. We've cited it in our complaint. So he committed the offense of cyber squatting. He took Mr. Bryant's distinctive call sign, and if one goes to that website, if you go to the k1dmr.com, it actually redirects you to Mr. Fields' harmful sites. So again, this is not just defamation. He's now cyber squatting, taking Mr. Bryant's call sign, taking those websites and redirecting people to his own website. But he didn't stop there. Mr. Fields is also an administrator of this Facebook group. He removed Mr. Bryant from this group. In addition, he didn't stop there. He did go on and...
How did he remove him from the group?
So this is probably not completely in the record, but my understanding would be that as an administrator of the Facebook group, he probably has the ability to remove certain people. I don't know about all the intricacies of that. But he removed Mr. Bryant from the group, which was harmful to Mr. Bryant because he used that professionally. Then what Mr. Fields did is he just doesn't stop. He did 2 things. One, he created a business card that would appear to be Mr. Bryant's business card. This card is in the record. This is a copy of it here. But if someone got this business card, there's a front and back, it would appear to be Mr. Bryant's business card. It says North Georgia Communications. And by the way, the Georgia connection is because Mr. Bryant is at a location in the state that's close to Georgia. So some of his business is Georgia, some is North Carolina. But he's in North Carolina. It's a North Carolina company. But in any event, Mr. Fields creates this business card that uses Mr. Bryant's company name, North Georgia Communications, his logo. It says Ken Bryant. It has his call sign, K1DMR. And on the back it says Scan for Deals. There's a QR code on here, and there's a website on here. And
Georgia, is that company a North Carolina corporation?
I believe that's just what he calls his company.
He does business as.
Yes, I think that's the
He's
DBA.
not a corporation. He's just, okay.
I believe he has an LLC, and he does business as North Georgia Communications, is my recollection. I believe the corporate name is Bryant Enterprises LLC. That would be the second named plaintiff in the case.
Counsel, is there assertion that the defendant knew Mr. Bryant lived and worked in North Carolina?
Basically, we have asserted that because Mr. Bryant, again, is one of only a relatively small number of Motorola dealers. Mr. Fields is in this industry. Obviously, he's in the ham radio industry. He works for Nokia himself. And he was contacting Mr. Bryant about products and services. So what we have asserted is that he did know where Mr. Bryant was. I don't think he's denied that he knew Mr. Bryant was in North Carolina.
And you've used the term doxing. And so were there, in fact, sort of North Carolina-specific information about your client that was disseminated?
The most important points would be the documents that were posted on Mr. Fields' websites. Again, these would be the wiki pages that he posted. Information, so documents that was obtained illegally from the PACER. If we go back to the criminal matter, those documents have been obtained illegally. It was those documents that he posted that has things on there such as Mr. Bryant's date of birth, other biological information, some medical information. So basically, those things which some people would want to keep private are published, and to the best of my knowledge, they're still posted today. So he's basically posting private information about Mr. Bryant on this website. So anyone could get Mr. Bryant's date of birth, which they could then, in theory, use to do things like identity theft and other things. But that's what the doxing allegations are aimed at.
I think what we're looking for is like, what are, where are the allegations that this conduct was directed into North Carolina, affecting North Carolina?
So
within the context of your
So
complaint.
that's the ultimate question. And so, but the reason I wanted to go through these facts is just to make the point, and I haven't even talked a lot about the sticker. There was also a sticker that Mr. Fields creates. It's literally a sticker. You peel off the back, and it has Mr. Bryant's face on it, and you can go paste it somewhere. And this, again, is designed to humiliate Mr. Bryant. The reason I wanted to go through those facts, though, is to make the basic point. This is not just a defamation case. The POPMA case we've been talking about, or Daly versus POPMA, the other big case in this area is the Young versus New Haven case out of the Fourth Circuit. Both of those are essentially fairly plain bread and butter defamation cases. And what those cases stand for is the principle that if someone defames someone else, it could be a Google review, it could be a Facebook posting. If you post something negative about someone else on the internet, that as a general matter, the prevailing black letter law is that does not subject you to jurisdiction in those other states. That's the core holding of the POPMA case. POPMA essentially took that holding from the Fourth Circuit cases. There's one called ALS scan, but the more pertinent one is the Young versus New Haven because that was a defamation case. But that is, if this were simply a defamation case, it very well may fall into that line of cases. But the reason I wanted to go into these facts is this case has gone far beyond defamation. Mr. Fields has cyber squatted on Mr. Bryant's call sign. He has created a fake business card and disseminated that. He has created a sticker and disseminated that. He has, I haven't even mentioned, he also created another website that is deceptively similar to Mr. Bryant's website. He basically copied Mr. Bryant's website with the exception of one letter, changed it by one letter. Again, trying to direct people to his websites and so forth. But here's the reason I go into all of this. This case is now far beyond just a defamation case, and so it doesn't really fall into the Daly versus POPMA and the Young versus New Haven line of cases. The critical thing to look at in this case is what we call the effects test. There are cases from North Carolina and the U.S. Supreme Court which say that in determining whether there's personal jurisdiction, you can look at where those effects are felt. So the leading case on this was the case of Calder versus Jones from the U.S. Supreme Court. That case actually involved Shirley Jones. That was the lady in the Partridge family. But in that case, she was defamed. She sued people in Florida. They said, look, we're in Florida. You're in California. You can't sue us. And the U.S. Supreme Court, the core of its reasoning was that the effects of what they did were felt in California, and they were felt by Ms. Jones in California. There's lots of language from that case, but the critical language toward the end of that opinion, the U.S. Supreme Court said, an individual injured in California need not go to Florida to seek redress from persons who, though remaining in Florida, knowingly caused the injury in California. So this is what we these days loosely call the Calder effects test. The basic issue is, can you look at where the effects take place? And the answer to that is yes. So in this case, obviously, Mr. Bryant is here, his business is here, he has a warehouse here, he ships from here. He provides this radio equipment to local first responders, your local police and EMT. They still use these things, and so Mr. Bryant, he's providing these.
Are his customers in North Carolina and Georgia, or does he have customers all over?
It's really nationwide. It is nationwide, but there would be more in North Carolina, and one of his affidavits addresses that point. Just as you would guess, there's more here, but he actually sells nationwide. But looking at the Calder versus Jones test, so in Calder versus Jones, that was the very issue the U.S. Supreme Court said, I believe it was a unanimous decision, that because the effects were felt in California to Ms. Jones, she had personal jurisdiction there. In that case, we're actually talking about the actual circulation of a newspaper, just to be clear, that wasn't the internet. But again, that's a paper that's, I think it was the Inquirer. But that paper is circulated nationwide. It's just that Ms. Jones was in California. Obviously, some of the papers would have physically gone to California. But in North Carolina, we have followed this Calder test as well. So we cite a couple of cases in our brief that also cite to this line of authority. One of the cases that we cite is a case called Saxon versus Smith. This was a defamation case in which someone in Virginia defamed someone in North Carolina. They sent out 1,500 newsletters. 100 of those came into North Carolina that defamed a person in North Carolina. And the Court of Appeals essentially looked at and went through the Calder effects test and said, when we're looking at torts, North Carolina has a great interest in protecting its citizen, and the effects of this defamation were felt here in North Carolina, therefore we have jurisdiction. Again, that's a case involving an actual newsletter, not the internet. That's the distinction. But the basic principle there would be exactly the same. The other case we cited is a case called Ciba-Geigy. I won't go into that, but that case also noted that we do look at where the effects take place, especially when it comes to torts and injuring North Carolina residents and businesses. One case I would submit, if we were looking for a case that's closer to what we have here, there was a case out of the Middle District of North Carolina, which wouldn't be binding on this court, but I would say basically this court, the Court of Appeals here, has decided to follow the cases coming out of the Fourth Circuit. It goes back to the ALS scan case and the Taylor versus New Haven case. We've basically adopted that line of reasoning. The Middle District is adopting that exact same line of reasoning. There's a case in our brief we cite called Lilly versus Gara. It's actually a fairly similar case that involved not just defamation, but a defendant who also had taken websites that were similar to the plaintiff's name, had taken the plaintiff's image. In that case, the Judge Osteen in the Middle District found that under this ALS scan test, the same test that we apply, there is personal jurisdiction over the defendant on these types of facts. So the key is we're not just looking at a simple case of defamation. Our brief also cites a couple of other cases out of Florida and North Dakota on somewhat similar fact patterns. But when we look at the case like Popma, for example, where you have the this I would submit as the primary case that the defense is relying on, the case of Daly versus Popma, where you had a person in Georgia defame someone in North Carolina. That didn't involve any of the facts we have here. In that case, for example, the person in Georgia, he didn't take websites that were similar to the plaintiff's name. He didn't create business cards and stickers to impersonate or embarrass the plaintiff. He didn't do any number of the things that we have in this case. So that's really the distinguishing factor here, is it's not just defamation, but it's really a campaign. And I would submit this is a somewhat unusual case. As lawyers, we sometimes see people get into disputes. It could be neighbors, spouses, any number, employer, employee. But our position is, and we submitted is supported by everything we've submitted here, that Mr. Fields basically entered into a somewhat, I don't say this to be insulting, but a malicious campaign against Mr. Bryant. There's nothing that would explain taking these websites, going to the trouble to create stickers, create business cards, all the things that he did. For some reason, he became very miffed at Mr. Bryant and decided to engage in this campaign targeted at Mr. Bryant. So that makes this case somewhat unusual. But the basic point is that when someone outside of North Carolina is targeting their conduct at someone in the state, this is intentional, it's repeated, it's not just one internet posting, there is personal jurisdiction. We cite a case from the state of Massachusetts that draws the interesting analogy. They say if someone outside of Massachusetts were to take a gun and shoot someone in the state of Massachusetts, we would still have jurisdiction over that because the injury is here. So conceptually speaking, Mr. Fields didn't punch Mr. Bryant, or he didn't shoot him with a gun. But basically, he's assaulting Mr. Bryant he's doing it from Florida. But it's the same principle. So that effect is felt here. when we look at personal jurisdiction, one of the things we're looking at is it foreseeable that he can be sued here? Yes, he's intentionally attacking someone here. As we also mentioned in our briefs, Mr. Fields has even posted about this lawsuit. He's made various comments about our court, our county. On his website, after the lawsuit was filed, he continues to make references to Mr. Bryant, to the case, even to Wake County, North Carolina. So in essence, we submit that Judge Rozier got this decision right. There is sufficient minimum context. Judge Rozier heard the evidence, listened to it at a lengthy hearing, and determined that there was personal jurisdiction over Mr. Fields. My opposing counsel has raised the question a couple of times as to try to reconcile the ruling between Mr. Galini and Mr. Fields. I'm happy to answer that question if anyone would like any insight on that, the distinctions between Fields and Galini. I don't want to waste your time if you don't have any interest in that, but there are answers to that question. They are in different postures.
Well, I see the Galini order is in this record, so I think it's fair game for you to distinguish those two if you can.
So just to put this in sort of a broader context, basically what happened here, and it's what we have in our allegations and our affidavits and so forth, we have alleged that basically Mr. Fields and Mr. Galini acted in concert in this campaign. And there are reasons we say that, and we elaborate on these in our briefs, more so in the brief on the Galini appeal. But basically, Galini took the links of Mr. Fields, and Galini posted those links on Facebook. So person A is posting links of person B, and then later, Mr. Fields on his website, he is posting text messages or these instant messenger messages that only Mr. Galini would have. So they are clearly acting in concert in some fashion. So we have alleged that they acted in concert here. But the bigger picture is, to be quite frank, we have basically submitted that Mr. Fields, he's the primary actor here. And below, let me just back up a second. So when Mr. Galini posted these links on Facebook, he posted the links that Mr. Fields had created, and he said something to this effect: "The Batman of the radio world strikes again." Mr. Galini is analogizing Mr. Fields to Batman. I would submit the significance of that is, if you know much about your superheroes, Batman is a good guy, but he's kind of a dark good guy. He's a little bit shady. So this is the implication, is that Mr. Fields is sort of the Batman of the amateur radio world. But the analogy that we drew below is that Mr. Fields, he may be the Batman in this, and Galini was essentially his Robin. So our basic position is Mr. Fields was more the mastermind behind this, and Galini was helping them. So if we were looking to reconcile the two decisions, there are distinctions between Fields and Galini, and I would submit that probably explains the decision on one versus the other. We, of course, have alleged that they were acting in concert such that they should both be held accountable for the same conduct. But in any event, that would be the answer in fairly simple terms as to the difference between Galini and Fields. But I'm so happy to answer any other questions about that. But most fundamentally, we would say Judge Rozier got this decision correct based on what Mr. Fields has done, his repeated conduct here. It is clear he was trying to affect, and did in fact affect, a North Carolina citizen, North Carolina business, under the Calder effects test announced by the U.S. Supreme Court and adopted by this court in the Saxon case and the Ciba-Geigy case that we've cited. And I would also reference again the case from the Middle District of North Carolina, which is fairly similar, the case of Lilly versus Guerra, that the North Carolina does have personal jurisdiction of Mr. Fields. It looks like I have a couple minutes left. Happy to answer any questions you may have. But I think that's all I have to say.
All right,
Thank you.
Thank you.
Rebuttal?
Yes, thank you.
Tell me why the allegation that your client printed cards and posed as a North Carolina entity, why wouldn't that be enough to give jurisdiction?
One, there's no competent evidence in the record. It's just bald assertions by Mr. Bryant that says that. It's not in the record. It's speculation and conjecture. One of the things that is in the record is an evaluation that Mr. Bryant had done on him when he was dealing with the Florida federal charges, which says he has a fanciful notion of, and some detachment with reality. I'm paraphrasing, but it's in the record. There's an element of paranoia here that.
Did Judge Rozier make any findings regarding those cards that were sent out? Did he make any findings?
Not specifically that I recall, but even if they were, Mr. Kirby mentioned the Massachusetts case. You don't need to go to Massachusetts. As I think Mr. Kirby confirmed in his argument, the Daley v. Popma case controls the outcome here. With the exception of the Lilly case that he mentioned from the Middle District, all of the cases that Mr. Kirby referred to are addressed factually and legally in the Daley v. Popma case. The Calder v. Jones case, that was a National Enquirer case. The largest circulation of the National Enquirer is not surprisingly in California. That is not the case here. There is nothing that shows that Mr. Fields got a gun, loaded it, and pointed it into North Carolina, and that was completely omitted from Mr. Bryant's arguments here.
Counsel, on that issue as far as knowledge, the plaintiff confirms that they assert that Mr. Fields knew that the plaintiff lived and worked, had a business in North Carolina. Was that contested by the defendant?
No, it's not contested, but the Daley case says that's not enough. Just to be clear, the allegations about cyber squatting attributed to Mr. Fields, it's just a bald assertion. There's no evidence of that in the record. The allegations that he's the administrator of a Facebook group and got Bryant removed is a bald allegation. There's no competent evidence in the record.
Well, but if somebody comes into court and is under oath and testifies, defendant took my web domain, defendant comes in and says, no, takes under oath, says, no, I didn't. That's a question of fact for the fact finder to decide with, weight, credibility, drawing, vocal inflections, body language, that kind of thing.
I agree with you, Judge Hampson. I think the difference would be that in that particular exchange, there would be, what's your evidence of that? Do you have the registration that shows Mr. Fields did this? Do you have the
That's what you would do on cross-examination.
Exactly.
And if he said, well, I dreamt about it, then obviously we would say that's not enough evidence.
And
But we don't have that. We don't have any of that because
I
you
agree.
didn't ask to cross-examine or even put on the stand, I guess.
Correct. And the second amended complaint was approved moments before we began our hearing on the motion to dismiss. Just make sure the information about the number of Motorola dealers in North Carolina is not in the record. Mr. Fields is watching. He texted me that the website for Motorola has far more than that. We're here in that day and age. The whole notion that Galini and Fields were in concert.
He texted you while you were here in North Carolina.
He did, here in this courtroom. And the notion that Mr. Galini and Mr. Fields were in concert is, again, pure speculation on Mr. Bryant's part. There's nothing. There isn't the first email, there isn't the first text, there isn't the first otherwise that demonstrates that that is accurate. I commend to you the great job that the panel did in the Daley case. It literally deals with each of these issues, including this whole notion that this is a campaign beyond defamation. The court deals with all of that and says you look to the facts and circumstances and look at the manifest intent of the defendant. There is literally nothing in this record that says, I'm coming into North Carolina to slap you around or do whatever. It's not there.
I guess, counsel, on that issue too, I guess, but are we at a stage to evaluate that final answer based upon it not being flushed out further with evidence at trial, whether it be pretrial motions or the trial itself? Because we do have a plethora of action, but the question remains that is that intent, because you're not denying there's action and a lot of it, and the potential,
not as much as he
not as much, but some of it, and the potential of harm in North Carolina. But are we at a stage where we have to make that determination at this juncture?
The issue in personal jurisdiction, Judge Gore, in my opinion, is it fair to have that decision made here in North Carolina? The plaintiff bears the burden to establish personal jurisdiction, and our argument is they have not put forward competent evidence to do that. And unless we have any further questions, I'll surrender the last 7 seconds. Thank you.
Thank you all for your arguments. We will take it under advisement. Thank you. And we'll be adjourned.
We're going.